Victor Mathis was charged with 2 counts of first-degree unlawful possession of a firearm. At trial, he testified he had never been convicted of any crimes in Georgia and that the crime the state claimed he was convicted of, armed robbery, was actually committed by his identical twin half-brother. Different mother, born on the same day. The jury found Mathis guilty, and he was sentenced to 8.5 years for each count. He was also charged for first-degree perjury resulting from his testimony stating he had no previous charges. He now appeals that conviction, disputing the fingerprint card evidence and the expert testimony met the higher standard of proof for perjury convictions. He also argues the fingerprint card was inadmissible hearsay. Mathis also appeals the sentence, arguing the court erred by ordering the perjury sentence run consecutive to his firearm sentence. Let's check it out.
Good morning. The next case on this morning's calendar is State versus Victor James Mathis. Counsel for Mr. Mathis is Ms. Wolf. Ms. Wolf, if you could begin your presentation by letting us know how much time you would like for rebuttal.
Thank you, Your Honor. May it please the court, I'd like to reserve 5 minutes for rebuttal.
Great, thank you. Please proceed.
Perjury has one of the highest burdens of proof known to law, and here the state failed to meet that burden. It did not offer sufficient proof that Mr. Mathis was convicted of armed robbery and burglary in Georgia, and so this court must reverse the perjury conviction. In the alternative, this court should accept the state's concession that resentencing is required. As the state correctly acknowledges, the sentencing court misapplied the law in running Mr. Mathis's perjury sentence consecutive to his sentence for unlawful possession of firearms. And if this court does remand for resentencing, it should also hold that 4 Georgia priors do not count towards Mr. Mathis's offender score because they are not comparable to Washington offenses.
Ms. Wolf, I have a couple of questions for you. One is with respect to the sufficiency arguments, and I guess to a certain extent the admissibility of evidence arguments, wasn't one of the exhibits that was admitted the judgment from the prior Klickitat County case?
I believe so, yes.
I think it was. And under the evidence rule that allows for admission of a prior judgment, it says the judgment may be admitted to prove any fact essential to sustain the judgment. That's just what 803A22 says, right?
I believe so, but the Klickitat judgment is not, the admissibility of that particular exhibit is not in question.
I know, but a fact that was necessarily established by that judgment was that Mr. Mathis had a prior felony conviction out of Georgia. That was the issue in that case, the contested issue. The state proved it beyond a reasonable doubt. He was convicted, and the judgment from that was entered into evidence and a necessary. Now, sometimes a judgment, there may be contested facts in a proceedings that lead to a perjury conviction that aren't established. But here, Mr. Mathis had a firearm, and the reason he was prohibited was because of felony conviction out of Georgia. His only felonies were out of Georgia. So why isn't it just, apart from the issue with the fingerprint card, why isn't that judgment and sentence sufficient to say you've already had this chance to say that wasn't me, a jury convicted you, that was established by your judgment and sentence, and that judgment and sentence was admitted here?
So I guess I would note it as a threshold issue in the personal restraint petition that I filed on Mr. Mathis's behalf, which I submitted a letter to this court alerting it to the crossover of potential issues. One of the issues challenged in that PRP is the sufficiency of that Klickitat conviction, convictions, plural. Second, this was a bench trial. We have the court's findings and conclusions of law, and it relied on the fingerprint evidence, not on.
Ms. Wolf, does the, I guess the burden of proving perjury, criminal perjury, is that higher than what was proven in the earlier case that he had this prior conviction out of Georgia, or is it the same level of proof?
So it's beyond a reasonable doubt, but perjury requires 2 independent pieces of evidence. 1, you need a credible witness, and then 2, you need either a second credible witness or independent corroborating evidence. So you need both.
So the judgment might suffice to be 1 prong there, but you still need to have a second prong.
Exactly.
Well, and you have him admitting to the evidence would be the officer says he admitted to it. But also, if you look at this fingerprint evidence and you compare it to his judgment and sentence, you see that they match. His judgment and sentence lists his prior convictions, which include crimes out of Georgia. This fingerprint card is not just a fingerprint card. It lists crimes. It lists how much time he got for those crimes. And that matches up when you look at his judgment and sentence. 5 years for, I have it on my screen, possession. Anyway, my eyesight is poor for reading that small on the fingerprint card, but it lists the various crimes, the various sentences he got. So it's not just a charge. It looks like this looks like he was convicted. I agree with you. This is not a judgment and sentence, but it appears to be a public record that was certified. And then you compare it to the judgment and sentence that was entered, and it shows he was convicted in Georgia of these offenses.
So the issue with the fingerprint card is that it's not a judgment and sentence, as Your Honor said. It just lists charges. It doesn't say that he was convicted of any of these things, and it doesn't mention
how much time he had. I mean, how could it list how much time he had if it's not evidence that he received time? Because it lists 5 years of count 1, 10 CC, 5 years count 9. Again, it's small. Count 8. It's listing how much time he's gotten for each one. So I would agree with you. If this was just a fingerprint card that is taken after a person is taken into custody, it would be questionable. But this appears to be, it talks about additional sentence. I mean, this lists the charges, and then on the box right below it, it lists how much time he got. And that could only be after he's been sentenced.
So I think the problem is that nobody testified about what those numbers and letters actually mean. Nobody testified that was the sentence that he received after a final judgment. I think also it's important to note the fingerprint card doesn't mention burglary at all. It's nowhere in that exhibit. And here, the conclusion of law was that the perjury that was committed was lying about being convicted of armed robbery and burglary.
Well, it says armed robbery.
It says armed rob star as a charge, but it doesn't say conviction.
No, I mean, again, I guess it's only on heightened perjury, but I think we can read things and say, well, that's what this says, and it's a document. It seems to be referring to robbery. And then you look at the judgment that was admitted into evidence. It talks about armed robbery, same year, same sentence. Well, the judgment doesn't list the sentence, but it talks about it's from Georgia and what year it was sustained. Why can't we make those inferences and just read it ourselves?
So the state had the burden of proof. Again, perjury is a heightened burden of proof. And this was the only evidence that was submitted that tied him to these alleged Georgia priors. And it's just a fingerprint card, as the trial court said in considering it. He said it's not a judgment and sentence. It's just a fingerprint card. It's not proof of an actual conviction. I want to turn to the sentencing issues to the extent.
Ms. Wolf, Judge Pinnell asked you a question earlier, and you were not allowed to finish the answer. It had to do with whether the underlying judgment in Klickitat County for possession of firearms as a result of being a felony was one of the two pieces of evidence that could convict him for perjury. Remember that question?
Yes, I do recall that question, Your Honor.
So interrupted, and I'm interested in the rest of your answer.
So my answer to that is, again, this was a bench trial, so we have the court's findings of fact and conclusions of law, and the court did not rely on the Klickitat conviction. It relied on the fingerprint evidence. That was what it found credible as proof of a prior conviction. And credibility determinations are left to the trial court, and I think that this court has to defer to those factual findings. Turning to the sentencing issue.
Let me ask you one more question on the conviction. Is Exhibit 2 admissible as a certified government record under that hearsay exception, as opposed to the final judgment exception?
So the state below and the court admitted it under the final judgment exception. And now for the first time on appeal, the state is alleging a completely different ground. And I think the case that we cited that they're precluded from doing that is Ferguson. So
I have a ton of questions about that. For one thing, the Ferguson case says that when you've lost an argument on appeal, you can't raise a new one. But generally, the rule is if you're the appellee, we can affirm on any basis. So the rules are a little bit different. But if you say, something is not hearsay, for example, in the rules, in the grounds, in the court below, and the court disagrees with you, you can't, for the first time on appeal, say it should have been admitted under a hearsay exception. You haven't preserved that. It's a little bit different when the evidence has come in and there's an additional reason, a valid reason to have it come in. But I do want you to get to the criminal history records, and I would like you to address, I'm concerned that Mr. Wall hasn't briefed the criminal history issues. And it could be that going forward at resentencing, he's conceded that there needs to be resentencing, that they would suggest different comparability. There could be different crimes that are comparable. And I'm just worried about us issuing an advisory opinion without input from the state when it all could be for naught, because they could say, well, actually, it's a different crime that's comparable.
So it's our position that the state in its sentencing memo laid out its analysis on comparability. And so we already know what the state's position on that is, and the court below made a ruling on comparability. And so it's now the purview of this court to rule on the comparability issues. To the extent that there are other felonies that may be comparable, again, the state didn't brief those issues. They didn't raise any other grounds for comparability. To the extent that there may be other felonies that are comparable, I did address that in the personal restraint petition. And based on my research, there are no other comparable felonies.
Yeah, I mean, he was sentenced for these in his prior offense too, so that may be raised, like you said, in the personal restraint petition, but that's a concern as well. It is, as a judge, it's difficult to think about, I'm going to be issuing a sort of advisory opinion when there hasn't been a full development yet, either on appeal or the possibility that at resentencing there'll be the state may disagree with you and think there's other crimes that apply. I have questions, for example, do we apply in Georgia? What is the rule in Georgia with respect to what facts are necessarily proven by a conviction? The state of Washington has certain rules with respect to, are you admitting everything that's charged, or are you only admitting what you said in your plea agreement? That's an issue of state law that needs to be briefed. There's also, do we go by, if we're comparing crimes, if the crime occurred in 1990 in Georgia, we look back at the law in Washington in 1990, or do we look at the law in Washington today? That's also a complicating factor that would need to be figured out. So there's complicating factors that would be helpful to get the state's briefing on before we issue an advisory opinion.
So to the extent, to go to your second question, Lavery, I think, is very clear that you compare the law in place in Washington at the time the crime was committed. So that is why I rely on Washington law that was in place in 1989 and 1990. I think given the fact that the state has not briefed this issue, this court can certainly adjudicate the comparability of the grounds that were alleged below and found by the trial court. I think if this case is going to turn on the comparability of those priors, then consolidation is probably appropriate with Mr. Mathis's personal restraint petition, and I would file a motion to that effect, in which I did provide briefing on additional potential comparable felonies, and the state will have an opportunity to respond.
You're on mute.
Sorry about that. You're well into your rebuttal. Do you want to reserve the remainder of your time?
I would like to, thank you.
Mr. Wall.
I think the court's questions addressed the sufficiency of the evidence, and I won't belabor that point at this time. I'd like to go into the comparability. In Washington, comparability depends on factual comparability or legal comparability. We're in a county where we're right across the river from Oregon, and as a matter of practice, I've basically given up on legal comparability because there's always going to be some difference in cases. So I would suggest, and what we do is I look at the charging document and then the resolution of the case. That's what I did in my sentencing brief. The issue of that Judge Purnell brought as the time, the law applicable, I have not looked into, and I don't have an answer for that. But more specific to this case is that the state wasn't really given an opportunity to do the comparability analysis. At the beginning of sentencing, we were prepared, and we weren't able to present our evidence because both the counsel for the defendant and the defendant agreed to his criminal history. So he acknowledged his criminal history and to a certain extent waived any argument about what his offender score was. He accepted the offender score that was listed in the JNS, and we went forward with the sentencing. But it would be fundamentally unfair to preclude the state from going through and proving his criminal history. We agree with the defense that the question of consecutive versus concurrent time was not addressed by the court, and we would ask the court to have a sentencing hearing for the court to make that determination. And I believe addressed in my brief that I did say that at that time we could probably do go through a full sentencing hearing with a comparability analysis performed by the court. But at this stage in the proceedings, it would seem that we're being foreclosed by relying on the representations of trial counsel and the defendant that was his criminal history. So if the court wants to set us back for an afternoon hearing to do that analysis, and that might foreclose further appellate review or PRPs, then at this point in time, he agreed with our criminal history at the time of sentencing, and we were prepared and ready and willing and able to go forward. But since they agreed, we didn't do that. And I think that's clear in the record, and I pointed that out in my brief.
Mr. Wall, how does that intersect with the PRP regarding the underlying firearms case? Because the similar criminal history is at issue there.
I'm not sure I understand your question, Your Honor. The PRP on the underlying firearms case has not been filed yet. I've seen the defense brief on that. Am I missing something? I could well be.
The representation is that one has been filed. I can't say that I've seen it myself, but
I think there was notice filed. I think there was a notice filed, but I think there was a notice that they were going to be filing it, but there hasn't been an actual brief that I have seen.
The PRP was filed about a week and a half ago, I think, and we considered whether to put the two cases together, and at this point we haven't yet consolidated the two. Ms. Wolf, a PRP was filed, correct?
Yes, I believe on January 7th, the PRP was filed. The verification is forthcoming. The issues raised in the PRP are the same comparability of the 4 Georgia priors, one of which is the basis for the predicate conviction for the firearms charge. So there's a sufficiency argument and there's a comparability offender score argument in the PRP, but they both rest on comparability.
And I don't know if it would make sense to, we could obviously hold the PRP, remand for resentencing and development of a record, since this, that could resolve some of the PRP. Or I don't know if there's other possible suggestions from the state's perspective, but it sounds like there will be 2 cases. I think I understand from Ms. Wolf, she would rather it be handled on an appellate level, that we decide both the PRP and this appeal, and then depending on what consensus we came to, remand for resentencing consistent with the terms of our opinion.
Well, I think that I think that if the court is inclined to to go back, we need to go back and get a record at this time to prevent, further questions down the road. We need to have, because in reality, the state has never proven, gone through a full comparability analysis. The first judgment sentence for his roof charges, I don't believe there was any real claim. We did a comparability analysis for the underlying armed robbery only because that was a necessary element of the crime that we convicted him of. But and then we went through sentencing, and I don't think that issue arose in that case. Then we come to the perjury charge, and then we have a situation where the state's ready to go, but again, both trial counsel and defendant agreed to what his criminal history was, and that prevented us from going forward with that, with the analysis. So,
although, as
so
you
if
know,
the court's inclined to,
as you know, by handling appeals, Mr. Wall, sometimes we will review things for sentencing, despite the fact that there wasn't an objection. The test is somewhat difficult for waiver at the trial court. But I do think that if it goes back, it would be very helpful for me at least, to clarify with respect to Georgia law, what facts are necessarily proven by a guilty plea. Are the facts in the information in Georgia proven necessarily by plea? And if sometimes there's extraneous facts in an information, maybe those aren't proven, but it could be an issue of state law with respect to, can a person plead guilty to a broader offense? Let's say that Georgia law is broader than Washington law. Nevertheless, Georgia in their information charged a more specific version that isn't broader. The defendant pleads guilty as charged. Does that guilty plea, is that limited to the language in the information, or is it broader encompassing because you can't divide down Georgia law? It's not that there are alternate elements, it's just one overarching crime that you can't divide down. So that's a question I have.
right, and from my memory, Your Honor, I believe that the Georgia informations, or actually indictments, listed the specific acts that he did.
They did, but I don't know that by pleading guilty, you're necessarily pleading guilty. Well, are you pleading guilty as charged? And if the offense itself is broader, even if the information charged a more specific subset, are you pleading guilty only to that subset, or are you pleading guilty to the statute as a whole, such as just an overbroad offense? For example, in Washington, you could charge an alternate means crime, and it could be that only one means is really proven, but by pleading guilty, you aren't necessarily admitting to all means. If a case had gone to trial, the state doesn't have to prove one means or the other. It just has to be sufficient evidence as to one or the other. So it's a complicated question as to Georgia law, what facts are established by a guilty plea.
and I, at this point, I couldn't tell the court. I don't know.
I don't know either.
I really have nothing further at this time. I do think we need to go back and sentence for consecutive versus concurrent. I don't think the court did the correct analysis. I don't think anybody brought it up. I know I tried to discourage it at the time of sentencing, and for that I apologize. But I do think that there is that they affirmed and accepted the defense at the time of sentencing. But if the court wants to overlook that, then we're ready and able to do a comparability analysis. And in terms of just as kind of counsel mentioned, the burglary charge. Well, the burglary charge is not found on the Georgia Department of Corrections. Well, the burglary charge is not found on the fingerprint charge because the burglary predated the slew of convictions that are referenced here. There's also convictions in Lackawanna, New York, for which he did about 2 years. And there's a conviction in 2013, I believe, for an assault of some kind. I thought it was an assault, maybe it was a sort of golden corrections fingerprint charge, because about 2 years municipal court. Memory serves, my calculations are that he had about 6 months before a lot of these things washed, but he didn't make it that far. So for that reason, I asked the court to finally waive the argument about his criminal history, resentence the defendant or have a sentencing hearing to determine consecutive or concurrent. And thank you.
Thank you, Mr. Wall. Ms. Wolf, your rebuttal?
Yes, so I'd like to address first the issue of whether remand is appropriate to do the comparability analysis, and second, the framework for the comparability analysis. So again, this was fully briefed by the state below in its sentencing memo, and this was raised in the context of ineffective assistance of counsel on appeal, to the extent that the state is arguing that it is unfair because there was an agreement or a stipulation below and it didn't have an opportunity to prove those priors. It did brief it fully below, and it also had the opportunity before this court to brief those issues and did not present any analysis. And at this point, it's really a question of law. There's no additional evidence that needs to be taken or proven or determined in the court below. This is a question of law that I think is appropriately determined by this court prior to remand. And I think that would lead to my second point in rebuttal, which is the proper framework for comparability. And I think this is really key. The state seems to be conceding that there's no legal comparability on these 4 Georgia priors. And so the question is really factual comparability and how that should be done. The scope of factual comparability has been limited in recent years due to constitutional concerns. I think that the Division I's analysis in Davis is really key to understanding how to apply this factual analysis, because what Davis says is that any facts in the charging documents that are untethered to the elements of the foreign crime are outside the proper scope of what courts may consider in the factual prong of the analysis. So to go to your question, Judge Pinnell, about what does Georgia law say, Davis is based on DeCamp, which is a Supreme Court opinion. And
DeCamp came out of my division of the federal court, so I'm fairly familiar with DeCamp. But my issue is, what does Georgia say? When you plead guilty as charged in Georgia, and the Georgia charging document limits the scope of the Georgia statute, what do they say? How does that operate? That's the question I have that I don't feel comfortable that I know the answer to.
So I know my time has expired, but if I could just answer your Honor's question. So I think to the extent that our cases in Lavery and Thomas and Davis interpreting DeCamp have held that it doesn't really matter what the law is in the foreign, in the other state. What matters is, for constitutional concerns, essentially, when you plead guilty, you are pleading to the elements of the foreign conviction and nothing more. That's what those cases say. And that's why your analysis on factual comparability has to be tethered to those elements, and anything outside the scope of those elements is beyond that.
Right, but how do they treat the elements? I mean, are they treating it as just an offense that is overbroad, or are they treating it as an offense that has alternate elements? And so by admitting to an information that charges in a way that's not overbroad, that charges required elements in a way that's comparable to Washington law, are you just admitting to those elements and is it satisfied? Or are you admitting to the broader offense, regardless of the fact that you were charged more specifically, because it's impossible to narrow down the broader offense? It's just a simply overbroad law.
So my understanding is you are pleading to the elements as charged, and if they are charged more narrowly, that's where the factual analysis comes in. So for example, here with the Georgia armed robbery, there's 3 alternative means, none of which are evident from the charging document. And so it is broader than the comparable, or what is alleged to be the comparable Washington offense. So does that answer your Honor's question?
I suppose. So you're saying that if the information is specific enough, then that's what's been pled guilty to. So we just look at the information.
Right. So if the two laws are not legally comparable, meaning that the foreign law is broader than Washington, if you plead guilty and the indictment, or in this case a special presentment, was narrower and had elements that were identical to or narrower than the Washington statute, then they would be factually comparable. But it has to be tethered to the elements of the foreign conviction. Your factual analysis must be tethered. Sorry?
You can't just put anything in the information and say that was admitted when it wasn't necessary for, if it was a jury instruction. It wouldn't be part of the elements of the offense in the jury instruction.
Right. And I think the error that has occurred here in the court below is looking very broadly in the special presentment to all of the facts that were alleged and saying, well, let's just look at his conduct that was alleged and make that factual comparability analysis. And Davis, DeCamp, Lavery, and Thomas all say that that is the wrong analysis. What you must do is you can only look to those elements that are tied to the foreign conviction. So it's really just, it's at this point, it's a question of law, right? It's not a factual determination. It's not a discretionary decision. It's a question of law, because the cornerstone, as Lavery says, the cornerstone remains the foreign conviction and those elements. So, I mean, that's why factual comparability has been limited so much in scope. And it's because of the Sixth Amendment and due process concerns.
I understand that.
Yeah.
Okay. All right. Well, we will take this under submission and get a decision out to you. Thank you so much to both counsel for your presentations.
Following these arguments, the court affirmed Mr. Mathis's conviction but remanded for resentencing, as he was not yet serving felony sentence at the time of the perjury. Well, let me know what you think in the comments below, and if you like this video, please consider subscribing to see a new video every week. Until next time, folks.